Good afternoon. Happy hump day. Part two, round fight. So, I got a question that had some allegations in it, and I figured it would be interesting enough to address. Apparently, allegedly, take this with a huge grain of salt because the information that was given to me might not be correct. But apparently, allegedly, Myers is going to somehow get the prosecutor on the stand and the victim on the stand and the victim's husband on the stand, or some combination of the three. I'm not, again, I don't have any direct firsthand knowledge of any of this. So, but apparently he's going to catch them all up in lies and yada yada yada. And first of all, that's not really a thing. It's not really an issue. It's not really relevant. The evidentiary hearing is going to be on whether or not to revoke his probation. And the underlying facts are going to be in the videos. And there probably will be some like custodian of records or something that's going to verify the videos, or the probation officer who pulled the videos off YouTube is going to testify when he got them and where he got them from, yada, 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 and that they're true and accurate copies, blah, blah, blah. But at the end of the day, I mean, unless defense doesn't require that and just stipulates that these are in fact Lane Myers videos from YouTube, or jailhouse calls from Lane Myers, and the defense might do that because, I mean, if it's uncontroverted that that's what they are, then why bother wasting time by putting a custodian of records on the stand who's going to testify exactly to that? So, I mean, I have stipulated to lots of documentary evidence coming in because it's uncontroverted. So they may do that just to save time. So at most, you're going to have like a custodian of records on the stand authenticating the videos and or jailhouse phone calls, and then the calls themselves and the videos themselves, the excerpts anyway, will be played for the court. So it's not going to be in my understanding, my best guess, my assumption is it's not going to be a heavily testimony-driven hearing. Lane Myers might want to go up on the stand to testify about maybe how the clips are out of context, or there's extra contextual information that might make them seem less bad, or whatever. He might want to do that. He might not. It depends on whether or not Resnick wants to put him on the stand, I guess. But that would really only be the only real actual firsthand percipient knowledge person testifying. If the victim gives a victim impact statement, that's just a victim impact statement. It's not under oath. It's not under penalty of perjury, not subject to cross-examination. It's not intended to be providing evidence of the violation to the court. It's to testify. It's for the victim to talk about how it's impacting her, which isn't relevant to the actual whether or not it's going to get revoked, but it might be relevant to the severity of whatever penalty the court is going to apply. So that's really what she would be talking about, not necessarily testifying about, because again, she wouldn't be under oath. And she might even make factual statements in there, but those factual statements are going to be understood by the court as to how she perceives them, how it makes her feel, not about whether or not the thing she's testifying or that she's talking about is a fact for the court's consideration on whether or not to revoke the probation. So, and I seriously doubt that Resnick would call the victim to testify and or her husband. And I strongly suspect the DA would heavily object if he attempts to do so. And I suspect the court may not allow it if Resnick tries. I mean, possible it comes in. Anything's possible. I talk about probabilities, and I don't think it's very probable. So, and then the attorney, the district attorney isn't a witness, isn't testifying. Any summaries, like factual summaries, like in opening statements or closing statements, aren't evidence in and of themselves. And if she misstates something, that's not her lying, and she's not going to get in trouble over that. I mean, if for some reason their evidence comes up somewhere where you could show that she is knowingly making a misrepresentation to the court, well, then the state bar might get involved, because you can't knowingly mislead the court. But notice it's knowingly mislead. So like if I go up on a motion or a evidentiary hearing, and I'm all prepared, I know what my client's going to testify to, I know my client's story, and I tell the court that I am going to show X, Y, and Z, and X, Y, and Z are what my client told me, blah blah blah, and I get him up on the stand, and for whatever reason he testifies to A, B, and C instead of X, Y, and Z. Well, I haven't knowingly misled the court, I was wrong, but you'd have to prove that I'm like intentionally, knowingly misleading the court. And you got to understand, like, every day the court is going to hear from two sides. One side says this is what happened, the other side says this is what happened, and it's the court's job, it's the role of court or the jury, whoever, to determine which side they believe and which side they don't, which inherently implies that one side is telling the truth and the other side is lying. That's the obvious implication. But the court doesn't treat it as someone is committing perjury. I mean, most rational, sane people understand that two different people witnessing the exact same incident are going to see two different things, because they're from two different vantage points, and they're going to remember two different sets of facts that probably will overlap, but may be different in certain aspects. One guy might remember somebody was wearing a red hat. The other person might remember they were wearing combat boots or whatever, So like, it doesn't mean that one party's lying and the other side isn't. It just means that they have different recollections. They were looking at different things. Their attention was drawn to different areas during the incident. And so there's that inherent kind of baked in, you're going to get two different stories when you're the judge, and it's your role to kind of parse through them and figure out what actually happened. But the DA is not going to get up on the stand. The Resnick's not going to call her. She's not going to get up on the stand. Resnick's not going to try to cross-examine her. I mean, it's all nonsense. It was a pipe dream. It was something that Myers wished he could do, but that's not going to happen. At least not at this hearing. I mean, maybe he'll file some motion somewhere, somehow, where he's intending to do it, but that's not even the subject of this evidentiary hearing. Thanks for watching. Have a great day.